have had the most time to talk.
You have had, second bites. Everyone has had this one.
The most time to talk.
Nana, maybe I'll start with you. Now, the CJ ran to ECOWAS, the ECOWAS Court, to seek an interim, injunction on processes to appoint a new CJ. The court says that, no, we disagree with you. And the court stated that Justice Torkornoo had failed to demonstrate urgent or exceptional circumstances to justify filing the application nearly 3 months after the action she complained of. I mean, what's in the ruling for Justice Torkornoo?
Thank you very much, Kojo. I believe that when matters of this nature come, we are supposed to discuss it without political...
Sorry, let me allot the time so that everybody knows that this is your time that you're dealing with. I'll give you 5 minutes on this topic. Let's move on.
And your time is 7 what?
It's mine is 7:58.
Okay. 6 seconds. Let's start. So I'll start in at 7:59.
Let's go. 58.
So, I'm using your timer here. We do this discussion without political colors.
Yeah.
Because at the end of the day, it is Ghana that suffers. You understand me? I believe that if we allow processes to go through properly without jumping on political colors and machines to move, we would have a very good system that we can operate with. Okay. So we would come and agree on matters, but yet we would point accusing fingers and try to say that people are manipulating or people have peculiar interest and for which reason they take decisions and for which reason they say whatever they want to say. And I think that was something that Hamza was even trying to deal with when Zato was saying that people in Jubilee House have interest in this whole office of the special prosecutor. What he has here. We all agree that the office has outlived its youthfulness. We all agree that the establishment of it, the reason why we established it, is not being fulfilled. So why don't we scrub it off? We make these commentaries a lot. And when we do with an understanding, we should not wear it political colors. Drawing it into Torkornoo's case. When this whole brouhaha started, I had said that when these lawyers try to play technicalities with us, as a nation, we are those that would suffer. And we need to take very decisive and firm decisions against these individuals. Kojo, I posed a question many months ago. I said that we have Article 146. I wanted any lawyer in this country to pinpoint to me, because I am not a lawyer, that there is any clause in that article in the Constitution that has been breached. No single person was able to pinpoint. I asked again, is there any process that has not been followed? Nobody was able to pinpoint that to me. And then I came back and I said that if there is even anybody who has breached Article 146 and the court procedures that I know of, then it is the former Chief Justice herself, when she came out to hold that press conference, because she actually addressed the press with details of the committee. And I posed a question that if anyone had done that, an accused in her court had done that and had come back to the court the following day, what would have been her comment before the trial? Kojo, you think that ECOWAS would sit and say that our entire judicial system should come to a halt because of a single individual? No. ECOWAS Court understands litigation, and they understand and they see a litigant when they see one. The third arm of government, the judiciary. The person who acts as a Chief Justice is not only a position. The person is the administrator the lead administrator of our judicial services and the chief supervisor of our judicial system, per the article that establishes the office of the Chief Justice. And so, if we do not have a Chief Justice as a country, the entire judicial system comes to a standstill because nobody would be there to ensure the administrative growth of the system.
But that's not the argument of the court. The court says that if you say if you say that if you are claiming for
they were talking about agency.
Eminent, exactly.
That's what I'm talking about.
Yeah.
So you will sit, watch the process for 3 months, and then you file. That is how litigants behave. At the end of the not the abeshaw. How many court cases does she have now?
But the court itself is willing to listen to the main issue.
Yes. Of course.
And
we are talking about the fact
responses.
that the judicial service cannot come to a halt because of an individual. The processes must continue.
But if you listen to the argument of the court, if she had come the time the application, the whole process had started, they could have listened to her.
When I was making my submissions, I said that they understand the processes and the steps of litigants. If she had gone earlier, probably by now it would have been done and dealt with. We wouldn't be here today. And I asked you a question, how many court processes has she filed? I'm told they have about 6 or so court processes being filed or in
so land for me.
So
your time is up.
You see, we would move from case 1, go to case 2, go to case 3, and then this judicial system of this country would be at a standstill, just waiting for one individual to finish litigation.
Thank you very much.
But I had also stated that I enjoy how she and her lawyers are managing and taking Ghana through a certain school, so that as a nation, we would all sit down and understand if indeed there is a need for us to have a review of 146, and if there is a need for us to indeed have a particular set procedure for this whole processes that we are undergoing.
Dr. Zato, what's the lesson in it, or what is in it for Justice Torkornoo herself and the nation?
Thank you very much. I have my position and my ideas on this Torkornoo case are well noted, well documented, everything. And I have stated, and I believe strongly that the removal of Justice Torkornoo through a highly charged, super partisan political process is one of the biggest achievements of the NDC.
How partisan was it when
very partisan, completely partisan and political.
Judges were the ones who were appointed to
completely partisan political. I can go through that process for you. Look, as I sit down with you here, do you know that there are petitions at the Jubilee House since January for the removal of EC? Do you know that? Do you know that you reported on those petitions? What has happened to them? Why are they locked up there? Why? Meanwhile, in fact, some of these petitions went there before the removal of Chief Torkornoo. Why is it that the Torkornoo's case has been taken and completed? Those petitions started, nothing has. Why?
So you want the EC to
No, I'm saying that.
See,
the power. See, he talked about the law. It's true. There are legal processes, but we've forgotten that there are forces. There is a force. The students of physics talk about motions, laws of motion. There are forces. There is a force in the Jubilee House that should move that petition to the appropriate quarters. That force is politics. So that is why they are certain that they've not gone. You tell me why.
But you have issues with it if it's
my point is, so that's what I'm saying. So it is the forces that can move a petition away from Jubilee House to the appropriate quarters to either establish prima facie or not. That force is politics. That's my definition of that policy. So so that when they put Jubilee House wants the case to go on, that force works with Usain Bolt speed to get the process done. When it doesn't want that to happen,
let's take it one after the other. Let's take it one after the other. Now, in all of those
I wanted to talk about the substantive case now.
Yeah, in all of those times, we had an acting CJ.
Yes.
Are you saying that now, if they move the Electoral Commission issue, the petition, as you talk about, to the CJ, because now we have a substantive one, to look into, that would mean that they were playing politics with it?
I'm saying that the fact that you received 2 petitions and then you chose one to go with supersonic speed and you left one is partisan. The decision to do that was also a political decision.
Anyway, make your point.
Thank you. Now we go to this. Look, Torkornoo has been going to Ghanaian courts again and again, and so far the score there has been 0. No court in this country has ever ruled anything remotely supporting her. I don't know. Maybe there's a lawyer, he may tell me that, oh, Torkornoo won this. But in this particular ruling from the ECOWAS, I think the score is 2-1. One, the Attorney General won the agency case. The people are saying that, look, hey, by the time you are coming, all the damage has been done. We cannot undo the damage. That's true. But that is the victory for the Attorney General. But one, he won victory because the first thing was that the Attorney General said that the ECOWAS Court, and before when she went there, I heard this argument from lawyers, whether they had jurisdiction. Yeah. ECOWAS says, one, we have jurisdiction. That was 1-1. Two, not only do they have jurisdiction, ECOWAS also told Attorney General, open your defense. That is 2. In other words, ECOWAS believes that some fundamental human rights issues were breached, that the woman has suffered some human rights injuries. That's what they are saying. That is, if not, they would have just
don't allow.
But your argument would have held if there was judgment that indeed.
No, but they say that.
When they say open your case, it doesn't mean.
But it means that a prima facie. Okay, does that mean the prima facie has been established?
No. They want to listen to the argument.
So no. So, okay. I will agree with Naraya. I agree. So if it's not true, I will agree with you. No worry, I'm not a lawyer. I don't argue on cases that.
It's not about. You are saying the prima facie has not been established. Talking about the establishment of prima facie.
So the court. So okay, that Nana, I've agreed with you. I've agreed with you, and I've withdrawn.
We have a lawyer here.
I've agreed with you, and I've withdrawn that. You see, I don't want. I'm not. I've agreed with you, so that has not happened. Withdrawn that. But something else. The ECOWAS has said that. Open your defense. That for me is also a victory for the woman, because now the state of Ghana has to now show that they did not breach her human rights, right? And for me, that is the good part. Look, these laws sometimes when they sit on our books for a very long time, nobody breathes life into them. They're just collecting dust. But this woman is prepared to make sure that every legal angle in this process is exhausted to its fullest degree. And I think that the legal system in Ghana will be better for us. I believe that it will be better for our legal jurisprudence. I believe that it's better for students of law. It's better for teachers of law. Because when you have these cases that have been determined, then they add to the general corpus of the law available to us. And I'm sure that tomorrow, if you're embarking on a similar thing, then it will be made sure that these things will serve as precedents. And these things will serve as what? Background. People will read it so that if we made mistakes, they will not make them. And it will help what? Enrich our law. And I'm also saying that because of this thing, the office of the CJ has become overly politicized now. We have a certain CJ now, and everybody I've spoken to say he's an excellent jurist, a very fine man. And that he deserves that office. He qualifies for it. Everything shows that probably this man was literally born for that office. Because if we look at his appointments throughout, done by bipartisan governments, and then you see what politics has done. This man deserves to have been heard by both the majority and minority, great on the law, these things before he goes. But you see what has happened. And that's what I'm saying.
But with your own argument, where does politics play a role? You say that the man is a fantastic
yes, no,
judge.
But that's what I'm saying. It's because the fruit of the political process of removing the man. The woman. So the woman was removed, and because of that, if you look at the decision by the minority to boycott this and to walk out of this, and it all stems from the way they also believe that the woman was removed fairly, and that the woman still had cases to a court to stop it. I'm saying that assuming none of this happened, assuming it was just an ordinary, boring, let's say, retirement of a chief justice, and the government had just appointed a chief justice, none of this would have happened. Going forward, my fear now is that any new government coming inside will come with their own CJ. That's my fear. That this process has now been... Because look, before this, if you ask me, I thought that the removal of a chief justice was almost impossible. I thought it was extremely so difficult that because of that, nobody will attempt or nobody will try it. But the events of this have told me that you need roughly about 5 months to get a new CJ out and bring a new one in. The events of this have now convinced me that it is not difficult to remove a chief justice of Ghana. And so I'm tempted to believe that precisely because of how easy and simple is it to remove the chief justice, that any government coming inside may be forced or compelled or will see political leverage, political opportunity, and bring their own chief justice. So we are going into territory that we don't know. And my point is that what will be the effect of this on the independence of the judiciary going forward? It might be compromised. And I hope that cooler heads will prevail going forward, that people will sit down and say, look, let this Torkornoo case be an aberration. Let this Torkornoo case be an isolated case. But going forward, we can do better and we should do better.
Thank you very much.
So, Doc, you want us to be the bigger people.
Let me bring in Hamza now. Hamza,
and I will have let me listen to them. They are from the opposition. If government will, I will respond before you say I don't have the right of response.
How's that you can do
that?
I give you all the time.
So I should keep quiet and allow...
Let me listen to you. Now, must this process get us to tweak the provision in the Constitution that has to do with the removal of the CJ? Just so we don't...
We have always maintained that, even around this table, that if there's a need for us to look at our constitutional provisions, not just in relation to Article 146, any other constitutional provision that we feel needs to be tweaked, the law allows us a certain process to do so. And around this table, I've had the benefit of also informing you and your viewers that our constitution has been said to be a living organism, meaning there's an opportunity for growth.
Yeah.
And you can make such meaningful incursions in terms of expanding the frontiers of our constitutional provisions, either through a constitutional amendment process or sometimes an expansive explanation of the law as contained in the Constitution through judicial decisions. So there is that opportunity for growth. So if anybody feels strongly about the way Article 146 is being applied in this country, it is within your constitutional democratic right as well to demand that we have a second look at that particular provision and any other provision or whatsoever in the Constitution. So that point needs to be made. This government and the NDC as a party will not stand on the way of any Ghanaian expressing views as to how certain constitutional provisions should be made to work. But, Nana, Kojo, I listened to Dr. Zaki. It was exciting listening to him because, first of all, when it comes to decisions of courts like the ECOWAS Court, one thing you need to understand, and let me introduce this caveat. I've not had the opportunity of reading the entire judgment. All what I've seen is news portals reporting on the said judgment. And so one can be forgiven to run on the basis of that to begin to score who has gotten 2 and who has gotten 1. But in law, it is basic that when a motion is filed and you have issues about the jurisdiction of the court to hear the matter, you are allowed to raise matters of jurisdiction without necessarily responding to the motion that has been filed.
Okay.
And that was what the Attorney General did. The Attorney General did not respond to the motion of the removed Chief Justice, Justice Torkornoo. What he sought to do was to question the jurisdiction of the ECOWAS Court to determine the matter at a time that many aspects of the matter clearly had some roots within many of our courts in the country. The ECOWAS Court says that, look, we have jurisdiction. And after asserting jurisdiction, the only logical thing a judge will do is to direct you to file your response.
And that's what they did.
And that's what they did. So it does not in any way suggest that by virtue of that directive, Torkornoo, in a way, or according to the court, there was basis for the allegations being filed against Torkornoo. No, the issue in contention was jurisdiction. And that was decided that, look, we have jurisdiction. And so let's respect it. Again, my brother raises issues about political insinuations as far as the removal process is concerned. Kojo, we're all in this country. When the MPP, through Article 146, removed Charlotte Osei from office, indeed, at the heat of the campaigns, they made promises that they were going to clean up the EC because they felt that, yes, there was something in opposition, unless you didn't follow them. Indeed, they came heavily against Madam Charlotte Osei.
Can readily recall.
Yes, they did. And so when they came, they actioned those promises because they believed that there was something wrong with the Electoral Commission. They just didn't succeed in removing one electoral commissioner. They swept the slate clean, the commissioner and her 2 deputies.
But you were in this country. If you hear that what was happening, would you have maintained them where they were?
Yes, because we maintained them in any case. We felt that there was nothing wrong with it and that the agenda was driven by politics. They were convinced that these people had to go. The NDC respected the outcome of their investigations, the outcome of the decision to establish a prima facie case by the then CJ, and the subsequent removal of Charlotte Osei. We respected it. Now, fast forward, the same Article 146, even before President Mahama became president, was invoked and petitions sent to Nana Addo Dankwa Akufo-Addo against the same Chief Justice, who has been removed. Mm-hmm. Petitions didn't start flying with the Mahama presidency. It predates Mahama presidency when it comes to Justice Torkornoo.
And the Council of State didn't find a premises.
So I'm just building a point. Mm-hmm. Okay. This is not the first time President Mahama has received a petition.
Your time is up. So
no, are you the host of the program?
No, he's not.
All of you. So
he's not. I've checked the time.
So who gave the time?
Myself, I did.
Kojo, I don't think that you wanted me to come on this show today.
Oh, Hamza.
How many minutes did you
Hamza,
give?
5 minutes. You've spoken for about 8 minutes.
Oh, Hamza. But you, why are you like this? I gave you the time. What
8 minutes? No, I'm losing the time here.
But let me land. Let me land.
Land for me.
Let me land.
No, we all
because I'm a lone ranger in this.
Everyone is a lone ranger on
No, they are not. They are from the same tradition.
Okay.
But you see, Nana, Kojo, the most important thing is that the Article 146 we are talking about today. In the past, we had petitions flying against a Chief Justice. By no means a person, but even a retired Supreme Court judge. President Mahama then did not act, even though that Chief Justice was the one who presided over the incarceration of one of our respected lawyers in this country and a proud member of the National Democratic Congress, Chachu Chikata. President Mahama did not activate or establish a prima facie case in relation to Georgina Woods. That was never done. That is principle. The same MPP accusing us of doing politics with it use Article 146. Yes, I'm London. They use Article 146 against Loretta Lamte, a Mahama appointee. President Mahama looked at the content of their petition and acted based on it. That eventually led to the removal of Loretta Lamte, his own appointee. What is the politics today? If the same president receives Article 146 and follows through the entire processes of Article 146 to get Georgina Wood, what's the name? Torkornoo, and based on the recommendations of the committee, Torkornoo has been removed.
Thank you.
The point I want to make finally on the matter is that, Kojo, we can all decide to run political commentary on the matter. The woman is doing the right thing by invoking our domestic laws and invoking international laws to assert her right. Let us respect that. And as a government, we have not done anything suggestive of the fact that we are against these attempts by Torkornoo to assert her right. Indeed, the government would be more than willing to support that initiative.
Thank you.
But when it comes to petitions, we would have no choice. If petitions are filed under Article 146 and there's merit in it, why wouldn't we run away from responsibility?
I have to talk to some of your teachers.
You attended a school called They never taught them summary.
Only a Tamil boy can say that and get away free.
He's saying that
only a Tamil boy. That's what I'm saying. That's what I'm saying. Only a Tamil boy can say that and get away free.
And interestingly, today we are in charge of running the country. Even the president and first.
But you know he started from.
The president.
The president started from Damascus.
You see, people, these guys are interested in.
The president started from Damascus.
We are having our 65th anniversary this weekend. So you are invited to.
So the president will be there.
The president started from Damascus.
Even those who went to Francis Xavier Junior Seminary are not talking. You are talking.
I'll tell Ibrahim Muhammad that you said school is not a school.
Even those who went to Xavier are not talking. They are talking.
It's fine. It's fine.
It's enough hours.
It's fine.
It's better than Ghana school.
How can Xavier be better than Ghana?
Come on.
When the president and first lady are speaking.
Oh, you're president and first lady. Then let's give it to Prempeh College.
We Prempeh.
You're talking about president. Let's give it to president.
You're
talking about president. Let's give it to the college.
Let the woman have his
Anyway, so the first thing I want to, because I know I will not be giving a right of response, let's not sit here and pretend like people in NDC do not want Hisia Jabin's job. Anybody that has their ear to the ground in this matter
we've moved on.
knows what's going on. That's all I'm saying.
We've moved on. Let's go.
That's all I'm saying. There.
Why I had to come in?
I have moved on.
No, but he responded. But let's not play around that thing. Everybody knows what's happening.
So you could get a job. That would be a very good appointment.
No, but that would be very confounding.
No, that would be a good appointment.
For who?
You.
No.
You don't want it? Oh. Okay.
So let's go
I'll
to the substantive matter of the...
I'm not qualified to sit in
of the former CJ. Anyway, that one I'll tell you after. I think a lot of things have been said about this matter, and we've spoken about it on this table several times. What is clear to all of us here and to all Ghanaians was that this was not a simple matter of rule of law or, allowing the processes to go through. This was a predetermined, pre-calculated attempt by the NDC in opposition to come into government and defile the judiciary of this country. It's something, surprisingly, they've been able to execute and get away with. And I'm actually very happy that the former Chief Justice is going through all the processes to at least establish that she was not treated fairly. And I think that's exactly what we are getting from the decision of the ECOWAS Court. Because not only did they establish that they had jurisdiction over the matter, they also found a prima facie case to hear the matter. So I think we should all be very interested to see how those processes pan out. I don't know how we can all sit here and pretend like it's business as usual. Firstly, I was very surprised that Hamza, who is a lawyer, so he falls in under the remit of the judiciary, wants to sit here and equate the Chief Justice, the head of the judiciary, to a former EC chair. Number two, the circumstances that were surrounding the removal of Charlotte required
is actually more important for democratic stability than the judiciary.
When we are talking about the three arms of government, do you see electoral commission?
That is your misconception.
No. When we are talking about the democracy over this country,
there's no democracy. There's no democracy.
Let me tell you,
the arms of government. If you have an electoral commission that is comatose.
Okay.
We are not saying the electoral commission. We're not saying the electoral commission is irrelevant. But you cannot to make your own point. You cannot. You cannot to just make your point. Want to equate the two.
No, in terms of the judges. Where does the Electoral Commission chairperson?
I am telling you.
Isn't High Court or something?
Yes.
Where does she come in?
High Court. So what are you?
So it means that the Supreme.
So you are comparing apples and oranges.
About the institutions, not the personalities.
With the removal of. Let me come on that.
Who is Torkornoo?
I'm
telling you that the Electoral Commission is like that.
Let her have a time to allow the woman.
It's not an arm of government. You cannot sit here one day and decide to make it an arm of government. It's not true.
If you want to go and not an arm of government, I'm telling you that it's actually the track of the branches of government.
There was procurement breaches. I've just sat here to open about 12 procurement breaches that they had against her. Funny enough, when I was reading the charge sheets about this SML thing, the chunk of the charges are procurement breaches. So we are all trying to sit around this table and agree that procurement breaches are, very weighty offenses. Not the same as traveling as with your family as a Chief Justice and all the other frivolous reasons. The frivolous reasons that were used to remove the head of the judiciary. Let's not sit down and try to belittle it. That thing always kills my soul. You cannot equate the head of the judiciary, the Chief Justice, to the EC chair. No disrespect to whoever the holder or the position of the EC chair, but they are not the same. And I do believe that the ECOWAS Court, especially with the things she has laid out, the relief she's seeking, I do hope that it will definitely go her way and a lot of things will become clear. Number one, when the president found this supposed prima facie case against her, there was no explanation. She didn't even know as to which of the three petitions that she was being, this commission, what I call a hung jury, whatever that commission put together was investigating her for. She had no idea. How can that constitute a fair trial? in a country like Ghana where we pride ourselves on democracy, and especially coming from a party that has demonstrated to us over the years their very uncomfortable relationship with the judiciary. In this country, when there's any big, sudden, unfortunate incident to happen with our judiciary, it is the hands of NDC are muddied and muddled and all over this matter. I was hoping that with the turn of the new century, a lot of us coming up, you know, it looks like all their evil deeds are being washed out of the memories of people. They would have let it stay there. But no, they came into office, and in their first 10 months, they want that to be their legacy, the removal of the Chief Justice of this country, and a very capricious and arbitrary means. There's no way you can look at this matter and then and not see that there was bias with setting it up. One of my panelists was also talking about how Article 147 was followed to the letter. I don't think you've
146,
listened. Yes, 146 was followed to the letter. I don't think you've listened to all the lawyers from all angles on this matter. Most of them would actually argue that it wasn't followed exactly. Because to be able to do that, you have to establish that there's no bias. You can't just take one article of the Constitution and run with it. You have to look at it in totality. And there's no way you can sit here...
Which was the accompanying article comes with the 146?
No, I'm saying that you have to look at...
it's a procedure. The procedure is there.
So you look at the procedure without looking at how you are going to use the discretionary powers available
discretionary
to you.
Power?
That's another article for that. Is it 297? Hamza, will you help me?
No, 146 is
296. Yes. So you cannot look at that in totality. I'm saying that the government, the NDC government had demonstrated bias even before they came into government with this. So you cannot then come and say that there was a certain petition that suddenly had the weight that rose to the authority of the removal of the Chief Justice. That's not true. Let's stop trying to lie to ourselves about that. It was a deliberate, basically it was a campaign promise by the NDC, and they've come and they've executed it. We can look at it that way, and then they'll forever be remembered as the political party, as the government that chose to make that their legacy. They chose to make that their priority. They've been talking about 24-hour economy for how long? We haven't heard anything about that. We know how they've let Ghanaians down on Galamsey, and this is what they choose to make their priority. Out of some misplaced priority. I don't know if they think that is how you can hold people accountable. But we have been able to, as a country over the years, establish a system of law where most people, most of the time, feel like they are going to get a fair hearing. But when you do this, remove the head of the judiciary, no mean person, you can just imagine the amount of fear you've put into the other judges now. Now, if I have a case with Hamza in court, there's no need for me to go.
Why?
Because all they need, sometimes you don't even need that call from. No, Kojo, let me land. And you know, a lot of these things are about perception. You don't even need to get that call from Jubilee House to put fear in you, because you've seen your boss removed unceremoniously over very frivolous charges. We know the way the NDC operates. If they had actual serious evidence against Justice Torkornoo, like procurement breaches, you know, things that we could actually sit down and say, oh, this woman did something wrong, and so because of that, she should be removed. They would have been trumpeting it from high heavens for the whole 10 months that they've been in power. They can never speak to the facts of the matter. All they say is that no law has been broken, because most of us are not lawyers, and so we cannot meet them on that tangent with a very effective argument. But the truth is, if they actually had wrongdoing against that woman, like actual clear basis to remove her, other than political motivated frivolous allegations, we wouldn't be having this conversation like that. And I'm very happy that the ECOWAS Court, which is not under the umbrella of fear that has been created in our judiciary, I'm hoping that they are going to at least be able to set some of these things right. We are just trying to, I think all of us should be eager to see if she has been treated fairly, if her right to a fair trial was given to her.
Okay, all right. Let me just add it so that you add it to your, bring in the hefty bail conditions as well, punitive or justice.
Yes. First of all, I think that it is important for me to make one important correction. I listened to my sister's attempt to downplay the significance of the Electoral Commission and the fact that we should not equate it to that of the head of the judiciary. One thing she has forgotten is that even her own presentation betrays the history of her party. Indeed, prior to 1992, there was a judiciary in this country. Prior to 1992, there was the executive. Prior to 1992, we may not have had the legislature, or we did not have the legislature. But even though there was judiciary, many of their party members and sympathizers of the Progress Party stock had to run away from this country. They did not use our courts. Why do you think that they didn't use the courts?
Because you had killed 3 judges.
Why do you think that they didn't use the courts? Because we did not have a democratic dispensation at play. So they had no confidence in what she wants to take pride in today and elevate to a status far and beyond that of the Electoral Commission. That is actually the fulcrum.
Yeah, that's what I said. Because you killed 3 judges.
So the murder of the judges by your founder had
It happened way back. The murder of the judges under the PNDC.
You said before 92.
I need to recollect you. You are a political science
You said
lecturer.
before 92.
But that's what I'm talking about.
So
But before 92, we
I thought the murder of judges has something to do with the baby.
Please, I'm telling you that. I'm telling you that before 1992, we had a military regime in place. Is that not a fact, Dr. Zatu?
That's a fact.
Before 92, we had a military junta in charge of the country.
Yes, and they killed it. It was there that they killed the judges.
So that's the point I'm making. That's the point I'm making. You understand? Oh, the PNDC killed the judges? Do you have evidence?
Did not happen under your tenure. When you were calling Nanado, a chief galamsea,
Anyway, but let me.
did you see him with his consent?
Before 92.
How can I explain?
Before 92.
Yes.
Then
And you said that the NDC, so I think that you should be invited because we actually are interested in going to there.
The judges were killed when he was leader of the country.
Are you going to allow me make my point?
No,
But
you
I'm
asked
making
me a
the point
question,
that yes, you should be invited. Because you have
No, but is NDC trying to dispute?
You want to say you're threatening me, Hamza? Come
No,
on.
I'm saying
It's okay. It's okay. Allow him to land.
The judges were killed when
We need to move on. Allow him,
this country.
Dr.
Isn't that
Zatu,
true?
allow him to land.
He brought that.
Allow him to land. We have to move on.
So if that's something as basic as the absence of democratic dispensation, many of you had to run away from the country and decided not to even patronize our courts.
Because they were killing judges.
Because that is what the lack of democracy do. Even if I am to accept the fact that they were killing judges, do they kill judges under a democratic dispensation?
You just remove them on service.
I'm simply a question. So that tells you the pride of
politically remove them.
But you people,
And you
want me to do that to you? So
Okay.
you can imagine.
Let me go to Nana.
No, please.
Oh, Nana, your time is up.
Interjecting.
I know, but I've given you two extra.
You can imagine. Doc, are you going to respect our viewers, please?
I'll give him time, so don't worry.
Okay. You can imagine what would have happened if we did not have democracy, if we had not conducted even elections. We would not have been at a place where we'll be having discussions about the removal of a chief justice.
Thank you very much.
So for us,
Thank you.
the NPP can decide to do all the politics it wants under the sun. Like we have said and we will continue to say, Madam Torkornoo can have access to our law courts. Madam Torkornoo, like Chachuchikata did, can also have access to international legal institutions to assert her right. Indeed, it is Chachuchikata who won that hall first in this country.
Okay.
When the NPP decided to massage the rule of law and brought down a judgment that was clearly contradictory to all the fundamental principles of rule of law and constitutionality.
I'm grateful.
And so for many of us, I'm London.
Today you've been too troublesome.
It's a planting.
Why are you doing this?
Because
planting.
So my advice to Dr. Ekuya
That's fine.
Dr. Zatu, let me end on my advice. My advice to Dr.
No, it's okay.
Nana, hold on, gentlemen. Let me hear from you. Nana.